Losing a loved one is one of the most difficult experiences we go through in life. During this period of heavy grief, you might find yourself suddenly faced with a confusing legal process known as probate. Our goal today is to demystify probate in a compassionate and straightforward manner to help ease your burden. Please remember, this video provides informational content only and is not legal advice. Always consult a qualified legal professional for your specific situation. When a loved one passes away, you might hear the term probate mentioned frequently. But what does probate actually mean? Simply put, probate is the formal legal process of administering a deceased person's estate. This comprehensive procedure involves several key steps: validating their last will and testament, creating a detailed inventory of all their assets, settling any outstanding debts, and finally, distributing the remaining assets to the rightful beneficiaries. You might wonder why such a formal process is even necessary. First and foremost, probate exists to validate the deceased's will, ensuring it is legally binding and truly reflects their final wishes. But it also serves a critical protective role. The probate court steps in to protect the estate's assets from potential mismanagement or fraud during a vulnerable time. Furthermore, it guarantees that all legitimate debts and final taxes are paid in an orderly fashion. Ultimately, the final and perhaps most crucial reason for probate is the legal transfer of ownership. Without this court-supervised process, it would be incredibly difficult to officially transfer the title of a house, a bank account, or an investment portfolio from the name of the deceased directly into the hands of the beneficiaries. Probate provides the definitive legal authority needed to make these asset transfers official. To understand probate, it helps to know the key players involved. Let's look at the 5 essential roles. First is the decedent, the person who has passed away. Next is the executor, or personal representative. This is the individual named in the will, or appointed by the court, responsible for managing the estate and carrying out the decedent's final wishes. Then we have the beneficiaries, or heirs, who are the individuals entitled to inherit the assets. But before they receive anything, the creditors step in. These are the people or companies owed money by the decedent. Finally, the probate court itself, which oversees the entire process to ensure everything is handled legally and fairly. The very first step in the probate process is filing a formal petition. This action officially opens the case with the probate court located in the county where the deceased lived. Once appointed, the executor must formally notify all heirs and beneficiaries about the probate proceedings. But it doesn't stop with family. The executor is also legally required to alert potential creditors. This is usually done by publishing a formal notice in a local newspaper, giving anyone the deceased owed money a specific time frame to file a claim against the estate. Once appointed, the executor's next major task is Step 3, inventorying the assets. This means identifying and valuing everything the deceased owned. This includes real estate, bank accounts, investment portfolios, vehicles, and valuable personal property like family heirlooms. All of these items must be meticulously cataloged with their current market value, compiled into a formal inventory document, and then filed directly with the probate court. Before any assets are distributed to heirs, the estate must settle its obligations. The executor pays all legitimate debts, including credit card balances, personal loans, and outstanding medical bills. They must also file final federal and state income tax returns, paying any taxes owed. Only after these debts and taxes are fully paid from the estate account can the remaining assets pass to the beneficiaries. Once all debts and taxes are fully settled, we reach the final stage, distributing the remaining assets. The executor must first seek the court's final approval to transfer what is left of the estate. These assets are then distributed exactly as outlined in the will, or according to state intestacy laws if there was no will. This final transfer brings much-needed closure to grieving families. The final step in the probate process is closing the estate. Once all debts are paid and assets are distributed to beneficiaries, the executor files a final accounting with the court. After the judge approves this report, The executor is officially discharged and the estate closes. This final step concludes a process spanning several months, finally offering closure to the family. One of the biggest questions families have is, how long will this take? For simple estates, probate typically takes 6 to 12 months, but complex assets, missing heirs, or will contests can easily drag the process out for years. Keep in mind, every state has different mandatory waiting periods. Then there is the cost. Probate is rarely free, and these expenses usually come directly out of the estate itself. The primary costs include court filing fees, compensation for the executor, attorney fees, and professional appraisal fees. Let us look at a hypothetical example in California, where fees can be based on the gross value of the estate. For a $1 million estate, attorney and executor fees alone could each reach $23,000, not including court costs. Remember, this is just an illustrative example. Actual costs and timelines will vary significantly, depending on your local laws and the estate's complexity. Probate is common, but often avoidable. One of the most effective tools is a living trust. By placing assets into a trust, they pass directly to your beneficiaries, completely bypassing the probate court. Another strategy is joint ownership with right of survivorship, where property automatically transfers to the surviving owner upon death. For financial accounts, payable on death or transfer on death designations, ensure your money transfers immediately to named beneficiaries without a judge's involvement. Finally, many states offer simplified procedures for smaller estates. In California, families can use a small estate affidavit if assets fall below a specific value, claiming them quickly and skipping formal probate entirely. While probate is a standard legal process, it isn't always smooth sailing. Families often face unexpected challenges, like will contests, where the validity of the document is questioned, or the stressful task of hunting down missing assets. You might also encounter disputes among heirs, unexpected tax liabilities, or complicated real estate issues like outstanding mortgages. The best approach? Keep communication open and consult a probate attorney or a tax professional to navigate these hurdles effectively. Navigating the probate process can feel overwhelming, which is why consulting a qualified probate attorney is highly recommended. For large, complex, or contested estates, having professional legal guidance is absolutely essential to avoid costly mistakes. You can easily find experienced professionals through your local bar association, by searching online, or by visiting the Probate US directory to connect with specialized attorneys in your area. Two common questions we often hear are, how long does probate take? Typically, it takes anywhere from 6 to 12 months. And do I need a lawyer? While not always legally required, it is highly recommended to ensure the process goes smoothly. Thank you for watching. We know navigating the loss of a loved one is incredibly difficult, but we hope this guide has helped demystify the probate process. Understanding these steps is the first part of moving forward with peace of mind. If you found this helpful, please like, subscribe, and leave a comment below with your questions. For more resources and guidance, please visit funeralus.com. Take care.